Yes, thank you for watching. Thank you for listening. Brighton Tejesh is my name, and I salute you all. Today, the topic of emphasis it is from land law, basically fixtures and chattels. So you have to put in mind that once you want to talk about fixtures and chattels, then you should be well conversant with what we call meaning of land. And in this essence, you have to differentiate very well between the two, a fixture and a chattel. And you have to know when is the fixture, when it is to determine a chattel. In this instance, by definition, a chattel, it is something, it is a property that is non-permanently attached to the land, which means it does not form part of the land. In this essence, you have to understand that a fixture, it is that thing that can be pressed on the land and can be removed without causing damages. Take an example, you can press a chair, you can press a furniture, you can press machinery, you can press, take an example, you can press a car, you can drive and park the car somewhere, and it is a fixture, it is not fixed in the land. But when you talk about the fixture, for a fixture, it is that thing that is fixed to the land, and which means it has become part of the land. When you try to remove it, it will automatically cause damages. Now, once it causes damages, it qualifies to be a fixture. Put in mind the Latin maxim of quick quid prante tu solo solo sedit. That means anything attached to the land becomes part of it. The house, it is a fixture, and other things. Now, once I have my house and I want to fix a window, I have brought the window from the furniture, then I fixed it in that house, it automatically crosses and become part of the land. Remember the Latin maxim which explains that quick quid prante tu solo solo sedit, bringing bricks, building a house, then it already automatically becomes land, which means the house, it is land. Now, when you look at the case of Hoyland versus Hogison, 1873-72, court established a two-part test. In this essence, it established the degree of annexation and the purpose of annexation. So, when you talk about the degree of annexation, it is how physically the attachment of an item is there in the land. So, which means if an item is on its own weight or can be easily removed without damages, it is more likely to be a chattel. Now, once something, the item, it is pressed on the land and by its own weight, when you hold it, you can remove it, it is just its weight that is settling on that land, it is a chattel. Then once it is fixed, that when you try to remove it, then it qualifies to be a fixture. So the degree, it shows how that thing is fixed to the land, to which degree, to which extent is that thing fixed to the land. So the degree, it explains, take an example, I may say I have pressed a stone, a very heavy stone, somewhere, but when you try to remove it, it's causing some simple damages, yes, however much, but the degree, when you look at the degree, it does not qualify to be part of the land. It is settling on the land by its own weight. Now, when you look at the purpose of annexation, so the question comes, we look on, was the item attached to improve the land or for the better use of itself. Here, by example, we look basically on the enjoyments. Something is fixed on the land. Something is fixed on the house. A good example is television dish. These things are fixed to the land, but being that their purposes are for enjoyment, then they can also remain chattels. They can remain chattels. Another thing is when you rent a house, then the nails that you want to put something, to hang something on them, the hang lines, some design, small design that you make, those remains chattels. They don't, however much they can cause damages. So that is the purpose. We look at the purpose, then we distinguish whether it is a chattel or a fixture. Now, when you look at the case of Lyon versus London City and Midland Bank, 1903, this is where a cinema hired sittings or chairs and they fixed them on the floor. But after some time, the cinema was mortgaged to the bank and and the operators defaulted. Yes. Now, the question at hand was, did chairs become fixtures or chattels? Being that the purpose of the chairs to be fixed was for the certain work or the certain duty, and then after the duty went off or expired, then there was no more use. The court ruled and said that they remained chattels, not fixtures. So in this essence, you have to understand. That's why we determined using the purpose and the degree to know whether it is a fixture or a chattel. So you have to understand more about on distinguishing. It is not everything that is fixed will become a fixture. Sometimes it will remain a chattel. Another thing, note, when you find it is agriculture items, agriculture things, sometimes those things remain. They are categorized under tenant fixture or agricultural fixtures. A good example is when you go and grow crops somewhere. Take an example, maize. However much they are attached to the land, but when you're going, you have to harvest your maize and go. However much they are attached, that is the purpose. Again, now there are tenant fixtures. Until you go with things, you rent the house, you fix them on the house, but at the time you want to go, you go with them. So you have to distinguish. You have to put in mind that. Thank you for watching. Thank you for listening. Stay blessed, subscribe, and be ready for another videos. Thank you.